for meeting out of the legal necessity, such as payment of antecedent debts incurred by the father of the dependents and grandfather of the plaintiffs as karta of the family, and also for discharging joint liabilities of the family. And consequently, according to these dependents, the suit property was transferred on 23/7/1988 for rupees 47,800, and this was done by the dependents to clear the antecedent debts incurred by the father of the dependent, Radha Prasad Singh. According to these dependents, there was no way out, and as a karta of the family, as a Hindu son as well as the dependent was under pious obligation to discharge the debt which was incurred by the father for legal necessity. And therefore the dependent first party just tried to justify the execution of the said deed. Another written statement was filed by defendant number
Defendant number one.
Defendant number one. Defendant first party and defendant number one अलग अलग क्या हो?
Defendant number one.
By defendant number one, asserting that the father of the defendants, namely Radha Prasad Singh, during the lifetime of the father of the defendants, namely Radha Prasad Singh, joint family was burdened with heavy loan, and Chandrashwar Prasad Singh was a patient of cancer and he was taken to Vellore for treatment and incurred heavy cost. This was followed by expenses for the marriage of the daughters of Chandrashwar Prasad Singh, and that this defendant had paid the entire cash amount at the purchase of the suit property, and it was agreed that the amount of rupees 20,000 paid by defendant will be reimbursed by the joint family. It was also asserted that the suit property was sold to meet the legal necessity of the family, and therefore the plea of cancellation of the said deed of 1988 was not in accordance with law. The defendant number two also filed a written statement stating that he was a bona fide purchaser for value, and defendant number one, being the karta of the joint family, consistent of descendants of Babu Radha Prasad Singh, and for legal necessity of joint family, had invested about 6 lakhs over construction and remodeling of the suit property. According to this defendant, the mother of defendant number one and grandmother of plaintiff also joined as co-executant in the Kevala executed by defendant number one as karta of the family. And according to this defendant, the suit property was purchased by Radha Prasad Singh by registered deed dated 11/11/1977. Radha Prasad Singh is the father of the plaintiff. Grandfather of the plaintiff. The following issues were framed by the learned trial court. Para 6. So far as issue number 5 is concerned, the issue number 4, 5, 6 and 8 were taken up together. The learned trial court
Paragraph 21 also.
has
Internal page 28.
come to a finding
Finding
in paragraph number
21.
21 that the as follows, para 21. The learned trial court held that the sued property was the joint family property and partitioned the property half and half, and also held that the plaintiffs are entitled to recover half share of the property from the purchaser. So far as non-joinder of necessary party is concerned, not much was argued, and ultimately the same was decided against. No finding was recorded. Before the learned first appellate court,
Paragraph 8, Lordship.
just plea was again
Want of
raised.
determination.
Just plea was again raised or regarding non-joinder of necessary party, which has been recorded in paragraph 2.2, and a plea was also raised that the property was a joint family acquisition and was transferred for legal necessity. The appellants before the first appellate court had also exhibited certain documents by way of additional evidence. As has been recorded in paragraph 3.1 of the appellate court's judgment. The appellant had also argued that the trial court had erroneously held that the plaintiffs are the co-sharers of the sued property, rather the sued property belonged to the family and it was joint family property. The point for determination was framed as under. The learned first appellate court recorded a a clear finding in paragraph 8.2 as under 8.2. Upon full reading of paragraph 8.2, this court finds that the learned first appellate court has recorded a finding that it was admitted by defendant number 1 that he, being the karta of the family, after the death of his father Radha Prasad Singh, had full right and control over the property, and exercising the right as karta, he sold the suit property for legal necessity. The learned court, however, held that the property was joint family property, but at the same time, and negated the contention of the plaintiff that the suit property is a separate property along with defendant number 1. The paragraph 8.2, when read as a whole, reflects that the learned first appellate court was of the view that the property was a joint family property and it was not the separate property of the plaintiffs along with defendant number 1. And the suit property was sold for legal necessity. The defendant number 1 was the karta of the joint family property. In continuation, in paragraph 8.3, the learned court recorded that the court has already held that the suit property is joint family properties of the parties, and defendant number 1 was the karta of the family after death of his father, namely Radha Prasad Singh. The court examined as to whether the suit property was sold for legal necessity or not. And the court also rejected the plea based on Benami Transaction Act by referring to the exception under section 2(9) of Benami Transaction Act. The court ultimately held that the defendants in the original suit were not able to prove the factum of legal necessity to sell the property. Then in paragraph 8.4, the learned first appellate court held that the suit property was a joint family property and there was no legal necessity to sell the property, and then considered as to whether the suit would fail on account of non-joinder of necessary parties. And while considering the point of non-joinder of necessary parties in paragraph 8.6 onwards, at paragraph 8.5 onwards, the learned court ultimately recorded the finding. At paragraph 8.7, the learned court recorded that as per law, those parties from whom no relief has been claimed may also be added, since they may be affected as a consequence of the decree. And in paragraph 8.7, the court recorded as under. The court also recorded that the daughter of the family was necessary party, and the court also granted an opportunity to the plaintiffs as to whether they wanted to include their sisters and also the legal representatives of grandmother as party to the suit. But the plaintiffs declined, and ultimately the court held that sisters of plaintiffs as well as grandmother of original plaintiffs were necessary party to the suit. As the nature of the property is joint family property, it is important to note that the as it has been recorded by the learned trial court itself, the PW1, one of the plaintiffs to the suit, had stated that the consideration amount of the suit property was paid by the mother after selling her jewelry, and it was decided that the property of Devkar be purchased in favor of plaintiffs and defendant first party. So the property of Devkar was separately purchased between plaintiffs and defendant first party. This court finds that once it was held that the property was a joint family property, the daughters were necessary party to the suit. The learned first appellate court has rightly held that the suit was bad for non-joiner of necessary party. Opportunity being given to the plaintiff, they did not avail it before the learned first appellate court for addition of party. This court finds no substantial question of law involved in this case, which is hereby dismissed.
Item 36, second appeal 125 of 2022.
This case for appellants are defendant number 2 and 3. The suit was filed, partition suit was filed by the plaintiff. The prayers which were made in the partition suit were kindly seen in the appellate court judgment, paragraph 2 at page 48.
At page,
Page 48, appellate court judgment.
just a
Paragraph.
the suit has been
Dismissed.
dismissed.
Yes. The appeal allowed.
You have challenged the sale deed.
The plaintiffs, they have challenged my sale deed, which
That was held to be barred by limitation.
it was held to be barred by law of limitation by the trial court also and by the appellate court also, both the courts.
So why are you agreeing?
In spite of giving the finding by both the courts, the appellate court held that my sale deed will not be binding upon the plaintiffs.
Who is in possession?
I am in the position. Because in the prayer they have claimed for possession also.
You are in possession by virtue of the sale deed.
By virtue of this.
The suit was filed seeking, challenging the sale deed.
My sale deed,
And also for partition.
also for partition and also for possession.
And also for possession. And ultimately the suit was held to be barred by limitation.
It was held to be barred by law of limitation by the trial court. Appellate court also affirmed the said finding. It was also held that sale deed is legal and valid. There is no fraud or impersonation. But my vendor had exceeded
His share.
his share. Now once the primary relief, that is my sale deed,
You see, the sale deed was held to be valid in the sense it was duly executed. But any vendor cannot transfer more than what he has. If his share was half share, so sale deed will be limited to half share only.
but this was not the case of the plaintiffs. This was never the case of the
The
plaintiffs.
plaintiffs claimed that it was vitiated due to fraud, etc.
The plaintiff was claiming that it was by a fictitious person. Sale deed was
So whatever it is, those findings, those plea was rejected.
those pleas were rejected.
The sale deed was held to be valid. This is one part. The second part is the court held that it was a joint property of the plaintiff and your vendor.
Vendor,
Then under such circumstances, if it was the joint family of,
no, it was the plaintiff is claiming partition from defendant number 1.
did it record a finding that it is a joint property of plaintiff and the defendant number 1?
It was our case that my vendor was the only son, Chaman Bhai, my vendor. It was the case of the plaintiffs that they have purchased the land from defendant number 1, and defendant number 1 claimed that Chaman Bhai was his stepbrother. Chaman Bhai was his stepbrother. The trial court held they were finding that Chaman Bhai was only single. He was defendant number 1 was not his was his stepbrother. But the appellate court,
But nobody. Defendant number 1 was nobody.
nobody. The trial court. But the appellate court upset the finding on the ground that burden was upon the defendant number 2 and 3 to prove that the defendant number 1 was not the stepbrother. The trial court had recorded a finding that burden is upon the plaintiff. So the appellate court held that burden has been wrongly shifted upon defendant number 2 and 3.
Let us see the trial court judgment.
Yes. Starts from page 12. Married
just refer to the paragraph number because I have the certified copy.
Yes. The issues are at paragraph 6. Now, issue number paragraph 6 at page 20.
Yes.
The issues were, I am reading.
Yes.
क्या वाद यथा निर्मित संधारण योग्य है? क्या वादी को वाद प्रस्तुत करने का कोई वाद हेतु प्राप्त है? क्या वाद परिसीमा से बाधित है? क्या वाद पक्षों के असंयोजन से बाधित है? क्या वादी द्वारा उचित न्याय से दिया? क्या सिदरा भुइयां को दो लड़के चमन भुइयां एवं झमन भुइयां हुए अथवा एक लड़का चमन भुइयां हुआ, और अगर सिदरा को दो लड़के हुए तो क्या झमन भुइयां की मृत्यु 20/5/1967 को होगी? क्या विक्रय पत्र संख्या 1763/71 जो वादी संख्या 2 एवं सूचित प्रतिवादी संख्या 2 एवं 3 के पक्ष में निष्पादित है, जाली शून्य, बिना प्रतिफल के तथा अपरिवर्तनीय है? क्या वाद पक्ष के अनुसूची बी की भूमि के आधे हिस्से पर वादी को कोई स्वतः अध्यासन एवं वित्त प्राप्त हुआ, एवं क्या वादी हाफ हिस्से के बंटवारे का अनुतोष प्राप्त करने का अधिकारी? Now, thereafter, at paragraph 8, the issue regarding that Sidra Bhuiya had only one son, Chaman Bhuiya, paragraph 8, the trial court has gave its finding. It's a long paragraph, paragraph 8, paragraph 9, it has been paragraph 8 and 9. The trial court held that इस प्रकार हम यह पाते हैं कि सिदरा को एकमात्र पुत्र चमन भुइयां हुआ। इस प्रकार that is at page 30, last 4 lines.
Internal page.
Internal page, मतलब internal page 19.
19. Candid.
Paragraph 19.
इस प्रकार
कहाँ लास्ट 4
इस प्रकार
इस प्रकार हम यह पाते हैं कि सिदरा को एकमात्र पुत्र चमन भुइयां हुआ। इस प्रकार यह वाद बिंदु वादी के विपरीत एवं प्रतिवादी के पक्ष में अभी निर्धारित किया जाता है।
So he was meant to be the sole son. Then
Thereafter,
who asserted that the plaintiff claimed to be the son of
the plaintiff, the defendant number 1 claimed to be the son of Sidar Bhuiya. Defendant number 2 and 3.
No, इस प्रकार हम ये पाते हैं कि सीदर का एकमात्र plaintiff also claimed to be the son of Sidar.
Plaintiff is the purchaser from defendant number 1, and defendant number 1 is claiming to be the son of Sidar Bhuiya.
How the purchaser filed a suit for partition
From through his vendor, defendant number 1.
Purchaser will challenge his own sale deed.
Purchaser is challenging my sale deed. Sale deed executed in favor of defendant number 2 and 3 executed by one Chaman Bhuiya.
That's not very clear. Please explain.
Sidar Bhuiya had
Just plaintiff claimed half share.
Plaintiff is claiming half share.
Half share.
Plaintiff is claiming that Sidar Bhuiya had 2 sons, Chaman Bhuiya and Jhaman Bhuiya. Jhaman Bhuiya is defendant number 1.
Chaman and Chaman.
Jhaman had executed half share in favor of the plaintiffs. in the year 9,
Chaman is defendant number 1.
he had executed half share
Half share
in favor of the plaintiffs in the year 1977.
to plaintiff in the year
1977.
1977.
Now our case is that Sridhar, I
You are
have
the defendant?
no, I am defendant number 2 and 3.
Okay. Defendant number 2 and 3 are the applicants.
Defendant number 2 and 3, they are saying, is their case that they have purchased the Sridhar Bhuiya had 2 sons, had only one son, Chaman Bhuiya. And Chaman Bhuiya had executed that fruit land 14.98 acres in the year 1971, entire land of Khata number 5. So the case of the plaintiff is that Sridhar Bhuiya had 2 sons. The case of the defendant number 2 and 3 that Sridhar Bhuiya had 1 son. The trial court recorded a finding that Sridhar Bhuiya had only 1 son, that is Chaman Bhuiya.
That is Chaman Bhuiya, and therefore the issue was decided in favor of defendant number 2 and 3. Then what happened? Before the appellate court?
The appellate court upset this finding, reversed this finding, holding that burden of proof has been wrongly shifted upon plaintiffs.
The burden of proof was with plaintiff. The vendor of plaintiff was defendant number 1. That is Chaman.
Chaman.
So Jharkhand had to prove that he was the son of Sridhar Bhuiya.
Chaman Bhuiya had examined.
So Jharkhand had to prove,
Had
no?
to.
So the onus was certainly on Jharkhand to
Jharkhand.
prove that he was a son of Sridhar
Yes.
Bhuiya. And the trial court and the appellate court has said the onus was with whom?
The onus was upon the defendant number 2 and 3 to prove that Chaman Bhuiya is the only son of Sridhar.
Only son, or Jharkhand was not the son?
Chaman was
It's the same thing. Either Chaman was the only son or Jharkhand was not the son.
not.
So when defendant number 1 was examined,
Yes, he was examined.
yes, then it was certainly for defendant number 1 to prove that he was the son of Sridhar Bhuiya.
He was the son of Sridhar.
So it was not a burden on the plaintiff, nor the court has held so. If I say that Mr. X is my father, then I have to prove.
Yes.
None else will prove it.
Yes.
I am the best witness and I am the best person to prove it. Defendant number 1 has failed to prove. Then, matter ends. क्या गलती?
Defendant number 2 and 3.
किसी को भी प्रूव करना हो, प्लेंटिफ को तो नहीं प्रूव करना है ना.
But my lord, he is claiming the land through defendant number 1.
Okay.
Now, it is either plaintiff or defendant number 1 to prove that they are the son of Sridhar. The trial court held that they failed to.
Plaintiff said that there are 2 sons,
Plaintiffs.
Chaman and Jharkhand.
Because defendant number 1 is
Is
not a
himself
contesting.
What do you mean not contesting?
He is supporting the case of the plaintiff. He is supporting the case of the plaintiff because he is not. We are disputing the defendant number 2 and 3 are disputing the case of the plaintiff.
Half share has been sold by defendant number 1 to defendant number 2 and 3.
Yeah, defendant number 1 had sold the half share to plaintiffs.
Sorry, defendant number 1 had sold the half share to plaintiff.
Yes.
And therefore, the defendant number 1 is supporting the plaintiff.
Supporting the plaintiffs.
So practically, defendant number 1 where's the finding of the learned first appellate?
Yes. Paragraph 25. That is at page, internal page number 32.
Yes.
Mary. In this case, although the defendant number 2 and 3 has came with a case that Sidra Bhuya had only one son, Chaman Bhuya, and he has pleaded the same. It is well settled a person who asserts he has to prove the said fact. If the defendant stated that Sidra Bhuya had only one son, then the burden to prove lie upon him to prove that Chaman Bhuya is not the son of Sidra Bhuya, rather he is son of someone else. But in this, so much no such proof was proved by defendant number 2 and 3. And the learned trial court has wrongly shifted the onus upon the plaintiff to prove the fact, as pleaded by the defendant number 2 and 3. In my view, the said shifting of onus is very obvious.
Chaman was also examined.
No, Chaman. Chaman has.
No, Chaman. You read further.
Yes. The learned trial court has disbelieved the statement of Chaman Bhuya on the ground that there are discrepancy in the statement of the date of death of Chaman Bhuya. But we forget that Chaman Bhuya is a literate person, and it may be possible that some calculating mistake may be occurred, and it is not sufficient to disbelieve his evidence. It is true that the plaintiff or defendant number 1 has not proved any voter list, family book, or any document, but on both he stated before the court that he is the son of Sidra Bhuya. And the defendant number 2 and 3 in their evidence has also admitted that Sidra Bhuya had 2 wives, and he has purchased from Chaman Bhuya, as they saw him in cultivating the land of Katanamur. Mere cultivation by a person cannot snatch the right of other brothers, and in my view, there is no reason to disbelieve the evidence of defendant number 1 that he is son of Sidra Bhuya. The defendant number 2 and 3 have filed certified copy of orders of some criminal cases, which was lodged against defendant number 2 and 3 by the Jamindar of City. in my view, these documents is not a proof of title and also not capable to hold that Sidra had only one son, Chaman Bhuiya. As I hold that Sidra Bhuiya had two sons, Chaman and Chaman Bhuiya. The land of Khata number 5 is 14.98 acres and Chaman Bhuiya has executed sale deed for an area of 14.98 acres, although he has one brother, Chaman Bhuiya. Hence, he has no authority to execute sale deed for the entire area of Khata number 5. Rather, he is only entitled to execute sale deed with respect to the half share of 14.98 acres of land. Hence, the defendant number 2 and 3 are only entitled to over half area of Khata number 5, and the plaintiff is also entitled to his half share over half area of Khata number 5. Chaman Bhuiya has executed registered sale deed in favor of defendant number 2 and 3, and the sale deed is registered document, and there is a presumption of genuineness of
Or the
the
learned counsel appeared on behalf of the appellants. The learned counsel for the appellants has submitted that the plaintiff claimed half share of the suit property, which was sold by defendant number 1 to the plaintiff by registered sale deed. The entire was sold or only half was sold?
only half.
He submits that as per the plaintiff, Jharkhand
Sidra
Sidra Bhuiya had two sons, namely Chaman Bhuiya and Jhaman Bhuiya. And Jhaman Bhuiya was defendant number 1, who sold his share to the plaintiff, and the half share to the plaintiff, and the plaintiff was seeking partition of the suit properties. The plaintiff had purchased the suit property way back in the year 1977. The learned counsel has submitted that the specific case of the defendant number 2 and 3 was that Sidra had only one son, namely Chaman, from whom they had purchased the property
through registered sale deed.
through registered sale deed dated
23rd January 1971, Exhibit C.
23rd January 1971, within bracket Exhibit C. The learned counsel has submitted that the trial court recorded a finding that Sidra Bhuiya had two sons.
Sidra Bhuiya had only one son, Chaman. Yeah.
Trial court has recorded a finding that Sidra Bhuiya had only one son, namely Chaman Bhuiya. And dismissed the suit.
Dismissed.
So far as the learned first appellate court is concerned, the appellate court was of the view that since defendant number 2 and 3 had pleaded that Sidra Bhuiya had only one son, namely Chaman, therefore it was for them to prove that Jhaman Bhuiya was not the son of Sidra Bhuiya. The learned counsel has submitted that the ownership has been wrongly shifted upon defendant number 2 and 3. He has further submitted that since the plaintiff was claiming that Sidra Bhuiya had two sons, Chaman and Jhaman, and defendant number 1 was Jhaman Bhuiya, who was supporting the case of the plaintiff, it was for them to prove that Sidra Bhuiya had two sons. He submits that the entire approach of the learned first appellate court in shifting the onus is erroneous in the eyes of the court. The learned counsel has also submitted that both the learned courts have held that the registered sale deed executed by defendant number 1 in favor of
by Chaman Bhuya in favor of defendant number 2 and 3.
By Chaman Bhuya in favor of defendant number 2 and 3. The challenge to the registered change executed by Chaman Bhuya in favor of defendant number 2 and 3 was barred by limitation. Still, the learned court first appellate court has allowed the appeal and made it clear that sale deed of the year 1971 executed by Chaman Bhuya in favor of defendant number 2 and 3 is excessive to his share, and the plaintiff and defendant number 2 and 3 were entitled for half share of the property. He submits that this was done after holding that Siddharth Bhuya had 2 sons, Chaman and Chaman, and therefore the plaintiff was entitled to only that's it. That should be sufficient. After hearing the learned counsel for the appellant, this appeal is admitted for final hearing on the following substantial question of law. बताइए कौन-कौन सा बनाएंगे? C.
C.
ये C है, पेज नंबर 6. ब्लैक किया हुआ है, मार्क भी किया हुआ है. And F also. The learned counsel has submitted that the appellants are in possession of the property,
Yeah.
and this was also apparent from the fact that the plaintiffs sought recovery of possession. Issue notice to the respondents under ordinary process and speed post, for which requisites be filed by Friday. How many of them are there?
बहुत सारे लोग हैं,
बहुत सारे.
15 लोग हैं. 1 week after vacation.
Within a period of 1 month.
After vacation तो बंद हो जाएगा.
1 महीना का टाइम आपको देगा. बीच में खुल भी रहा है ना, दुर्गा पूजा में आप वेकेशन में है क्या?
नहीं, तो आ ही जाएगा.
दुर्गा पूजा में वेकेशन में नहीं है ना, तो खुल जाएगा. ठीक है. ऐसा कोई प्रीएम्प्टिव ऑर्डर नहीं था. Post this case on 1st of December, awaiting service. Let the records be called for from the concerned. आपका आर्गुमेंट हमको हमेशा बहुत अच्छा लगा. You prepared well. Mr. Sharma, yesterday we had framed substantial question of law. उसमें एक substantial question of law आपके आड़े आएगा, मतलब एक finding वो section 34 का भी बना देते हैं, नहीं तो section 34 आपके against में रह जाएगा तो फिर आपको relief कैसे मिलेगा? Appellate court hold किया है, it is barred by section 34. ठीक है?
One on limitation can also.
Limitation भी आपके against में है.
Limitation can be made.
I can do one thing. I'll keep it open to you for additional substantial question. कल जो बनाए हैं उसके अलावा इतना observation रहेगा, then you can file an appropriate petition. ठीक है?
And we're waiting for orders, item 11, second appeal 510 of 2016.
In this particular case,
Conclude.
is a fight to IS today. So, the appellant number 2 has died.
Who has died? Sorry?
Appellant number 2.
Okay.
Appellant number 2.
एक respondent number 2 का भी है.
Second वाला में से.
Sorry?
Second वाला में सही, इसमें हम भी देखते हैं.
एक
It's
respondent
the
number.
appellant number 2. I have filed वकालतनामा.
किसका डेथ हुआ है? अपील नंबर 2. एक सब्स्टिट्यूशन नाम सही है ना? रामेश्वर वैद्य,
वो ठीक.
रामकेश्वर वैद्य, नाम सही है ना?
नाम
चेक करिए.
इसमें गलती है.
हाँ, अपील नंबर 2 है.
इसमें ठीक.
इसको ठीक कर देंगे भाई, तो गड़बड़ हो जाए. हम ऑर्डर कर देंगे. वकालतनामा कहाँ है आपका? आपको कोई ऑब्जेक्शन है? विद इन टाइम
125 days का डिले है.
125 days. अब अपील कब से पेंडिंग है?
फिर तो 16 से पहले.
ना तो डिले करना पड़ेगा. आइए नंबर 13476 of 20. नहीं 13475 of 25 has been filed seeking substitution of Ramkeshwar Vaidya, who is said to have expired on 19/2/2025.
प्रेयर में भी ठीक है. इसमें बॉडी में फर्स्ट पैराग्राफ.
He is appealant number 2 in the present case.
Paragraph written for the details of legal case.
A prayer has also been made for condonation of delay of 125 days and for setting aside abatement. And a petition for a separate petition for condonation of delay being IA number 13476 of 25 has also been filed. The details of legal years and successes of the deceased appellant has been mentioned in paragraph 5 of the interlocutory application. The learned counsel submits that the wakalatnama has also been filed along with the interlocutory application. The learned counsel for the respondents.
Waiting for 8 notes.
I have no serious objection so far as substitution is concerned. The fact remains that the second appeal has remained pending before this court since 2016. After hearing the counsel for the parties, ID number 13476 of 2025, seeking condonation of delay, and IA number 13475 of 25 seeking substitution and also setting aside abatement are hereby allowed. The counsel for the appellant is directed to delete the name of the appellant from the cost appellant number 2 from the cost item and insert the names of his legal heirs and successors in writing during the course of it. बताइए disposed of. आगे का क्या story?
correct it, the respondent number 2 and maybe corrected it.
At this, the learned counsel for the appellant has submitted that in IA number 13475 of 2025, at certain places, instead of at para 1, instead of appellant number 2, respondent number 2 has been inadvertently typed, but the name of the appellant number 2 has been rightly mentioned. He seeks permission to carry out necessary correction. Needful be done by the appellant in writing during the procedure. Okay? और बताइए अब क्या?
Yes, this is for admission. This matter is today for admission.
तो आप लोग क्या कर रहे हैं? रेस्पोंडेंट को क्या हो गया? आप लोग
Respondent पे जो notice हुआ है
सो वोटर अपील हुए हैं?
नहीं लॉर्डशिप, नोटिस हुआ था, नोटिस से है।
नोटिस किस चीज के लिए?
नोटिस इसमें अपील में ही नोटिस हो गया था. I would like to show something. So last में kindly see the supplementary.
सप्लीमेंट्री अपील?
Yes.
किसका सप्लीमेंट्री?
हमने पाया.
कब फाइल किया?
ये फाइल हुआ था June 22 में फाइल हुआ.
क्या दिखाना चाह रहे हैं बताइए?
Certified copy of order भी उसके साथ ही है.
किसकी? ये क्या चीज? क्या चीज है?
दिखा हमने ऑर्डर 41 रूल 27 का पिटीशन फाइल किया और लर्ड एपेलेट कोर्ट में इसको सुना और 28/6/2016 पेश
एक अलग ऑर्डर से इसको
नहीं, इसको इसी ऑर्डर से डिसमिस किए, इसको रिजेक्ट किए. उसके बाद खाली लास्ट पार्ट हम क्लियर करना चाह रहे हैं. Accordingly, petition dated such and such are hereby rejected. Put up the record for judgment after lunch. और लंच के बाद सीधा जजमेंट ही पास किया, जो कि इम्प्रूव है. हमें कोई अपॉर्चुनिटी नहीं.
नहीं क्या चीज? ये एडिशनल एविडेंस है ना?
एविडेंस नहीं.
एडिशनल एविडेंस तो फाइनल जजमेंट के साथ में ही पास होता है।
फाइनल जजमेंट के साथ पास आप अगर करते हैं जिससे
तो
हमें तो कोई अपॉर्चुनिटी, हमें तो कोई
अपॉर्चुनिटी
हम इसको सुप्रीम कोर्ट में चैलेंज कर सकते हैं।
देखिए एडिशनल एविडेंस का जो भी पिटीशन होता है दैट हैज टू बी टेकन अप एट अलोंग विद द फाइनल हियरिंग।
बट माय लॉर्ड, यूनियन ऑफ इंडिया वर्सेस इब्राहिमुद्दीन का जजमेंट उसके लाइट में हजूर इसको पहले अपील को सुनना और अपील के सुनने के बाद पहले ये चीज कोर्ट एक ओपिनियन फॉर्मुलेट करेगा कि वेदर हैज टू बी अलाउड और उसके बाद उसको अलाउ करेगा। लेकिन ये पर्टिकुलर जो कि हम लोग का जो पिटीशन था, दिस डॉक्यूमेंट्स आर ऑलरेडी ऑन रिकॉर्ड और ये डॉक्यूमेंट को हमने सिर्फ इसको तो लोअर कोर्ट में ही एग्जिबिट हो जाना चाहिए था, लेकिन एग्जिबिट उसको नहीं किया। तो उसके खिलाफ भी हम लोग के खिलाफ भी उसमें लिखे हैं कि सलामी नहीं है, ये नहीं है, कोई जिम्मेदारी रसीद नहीं है। लेकिन ये सब रिकॉर्ड तो था
नहीं। जस्ट अ मोमेंट, यू सी द कोर्ट इन दिस केस इंस्टेड ऑफ passing a composite order, your additional evidence has been rejected.
It has been rejected.
Yes. Instead of passing a composite order and dealing with the additional evidence in the final judgment itself, on the same day has passed it through.
No reference of even in the judgment there is no
Need not be there. You have annexed it. It is on the same day.
That's what I am saying.
Yes.
My point is that if any learned court if rejects the petition, whether I am entitled for where am I entitled for any
Mr. Sharma, एक भी हम लोग फर्स्ट अपील सुनते हैं। फर्स्ट अपील में जो एडिशनल एविडेंस का कंसिडरेशन है, फर्स्ट एपेलेट जजमेंट मिल रहा है और आपको अगर उसके अगेंस्ट में आपको कोई ग्रीवेंस है, then you can have your remedy. सेकंड अपील में सब्सटेंशियल क्वेश्चन ऑफ लॉ बनेगा उसमें। लेकिन आप ये नहीं बोल सकते हैं कि the additional evidence has to be, there are certain orders, आपको तो पता होगा
अरे हम
कि अलग से पास करने से कोर्ट हैज डेप्रिकेटेड दैट इट शुड नॉट बी सेपरेटली डन।
अदरवाइज जजमेंट नहीं है क्योंकि इसको
नहीं,
पहले आपको इसमें
अब
इसमें
उसके लिए ये जो सुप्रीम कोर्ट में जो कॉन्स्टिट्यूशन जजमेंट आप बोल रहे हैं ना, उसके लिए आपको सुप्रीम कोर्ट ही जाना है।
अपॉर्चुनिटी देनी है,
नहीं
ये बात है।
नहीं नॉट
ऐसे ऐसे अगर मान लीजिए ये हमारे डॉक्यूमेंट्स अगर कोर्ट में तो इसको डिक्लाइन कर दिए। अच्छा अभी के समय में अगर हम इसको हो सकता है सुप्रीम कोर्ट में आते मेरा
नहीं तो अभी जो है सब्सटेंशियल क्वेश्चन ऑफ लॉ में आप उनको समझाइए।
हम लिए
नहीं तो फिर we will scrutinize this order also and find out whether it has been rightly rejected or wrongly rejected.
दैट विल आल्सो कैन
Only that we can do.
वो हमने पॉइंट लिया।
इसमें क्या आप ऐसा लगा लेते हैं?
नहीं ये नॉर्मली ऐसा नहीं होता
नॉर्मली नहीं, सारे केसेस में ऐसे ही आ रहा है।
है। लेकिन ये प्रोसीजर
नहीं प्रोसीजरल एरर नहीं है, यही प्रोसीजरल।
सेम डे आप कैसे
सेम डे नहीं, rather इसको तो composite part होना चाहिए था final judgment. It should have formed a part of the final judgment, but the court on the same day, instead of dealing it in the final judgment, has dealt it in the separate order, and on the same day the judgment is passed.
हजूर को हम इसमें जजमेंट
नहीं आप judgment
हम दिखाएंगे इसमें कि इसमें अपॉर्चुनिटी देना
नहीं, please don't tell me this.
दिखाएंगे।
तब तो हम लोग का सारा जजमेंट ऐसे ही खत्म हो जाएगा। सुप्रीम कोर्ट का यही जजमेंट है ना, लाए हैं आप?
ऑर्डर 41 को
एनसाइक्लोपीडिया यही है,
कौन सा जज
2008 SCC 148।
So by order 41
तो जब लोग ऐसा बहस करते हैं ना तो हमको लगता है हमको उनको बेवकूफ
नहीं
समझते हैं।
हम
फिर
हजूर
क्या?
आप
एकदम सेटल लॉ है भाई, फर्स्ट अपील के साथ सुनना है सारा इंटरलोक्यूटरी एप्लीकेशन।
इससे एक बार ऑर्डर 41 को देखा जाए for my satisfaction you may not be kindly sure
2015 का भी जजमेंट सेम आया, 2022 में भी सेम जजमेंट आया।
ये सही नहीं है, ये आपका जो आप सोच रहे हैं वो बिल्कुल सही नहीं। रादर इस तरह के ऑर्डर्स जो हाई कोर्ट ने किए हैं अलग से जो ये पिटीशन रिजेक्ट कर दिया है, तो पीपल हैव बीन चैलेंजिंग दिस ऑर्डर दैट दिस हैज टू बी नेसेसरीली टेकन along with the final disposal of the first appeal, and on that ground those orders have been set aside by the Honorable Supreme Court.
Correct.
Union of India versus Ibrahim मुझे तो ऐसा नहीं as I remember correctly remember
नहीं तो अगर आप कुछ ऐसा बोलेंगे कि ऑनरेबल सुप्रीम कोर्ट के कॉन्फ्लिक्टिंग जजमेंट है तो हम अपना रिकॉर्ड कर लेंगे उसको
Additional evidence
और भेज देंगे आपको
ऐसा हम नहीं
पार्टीज को
ऐसा हम नहीं
कि आप उसको रिजॉल्व तो वहीं से होगा अगर कॉन्फ्लिक्टिंग जजमेंट।
जजमेंट जो my learned friend ने जो कहा है वो like
लॉर्डशिप में सबमिट लॉर्डशिप
ऑफ हैंड
जब एडिशनल एविडेंस अलाउ होता है तब टाइम दिया जाता है अपोजिट पार्टी को टू रिबट द सेम, बट वंस इट इज डिसमिस्ड देन देयर इज नो चांस ऑफ रिबटल, therefore it has been rightly decided even at the time of final disposal it has been dismissed, hence no need for rebuttal. The time that the court grants, that is for rebuttal if additional evidence is allowed.
नहीं रिबटल का तो जजमेंट हमने एक आध दिया फिर उनको उसको उसमें दो ही कोर्ट से उनको चाहे तो रिमांड करेंगे या फिर ऐसे आप बिना रिबटल के आप सेकंड अपील
भाई इनका कहना है
नहीं यहाँ तो रिबटल का इशू नहीं है यहाँ पर तो मेरा हमारा प्रेजुडिस का इशू
कोई prejudice
has got prejudice that what I'm doing
नहीं, if it has been rejected it will form a part of substantial question of law
नहीं,
if the
नहीं,
court is satisfied।
I have already made it that part I have made
आज तो नहीं होगा, आज तो बिना सुने कैसे ही होगा। इसके अलावा भी कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ है?
I have framed all substantial questions जो कि इसे raise होना चाहिए
Actually, my letter penal lord say wanted to remand the matter before the first appellate court. According to us, my lord.
that would be better
नहीं।
I might
इससे उनको क्या फायदा होगा?
कोई फायदा
फायदा प्रेजुडिस जो है मेरा कम से कम वो तो डिस्पेल होगा। ये हम दोनों कोर्ट ने कहा है कि आपने फर्दर मीन रिपोर्ट नहीं लाया और आप जमींदारी रिसीट नहीं लाए और जबकि जमींदारी रिसीट और फर्दर मीन रिपोर्ट ऑलरेडी ट्रायल कोर्ट की रिकॉर्ड फर्स्ट एपेलेट कोर्ट के सामने हमने कहा कि आप इसे एग्जीक्यूट करें उसके बाद इसको सुनवाई करें तो उस दिन ही रिजेक्ट कर दिए, हमें कोई ऊपर जाने का भी कोई मौका नहीं मिला, सीधा ही ऑर्डर कर दिया।
तो उसको सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाएंगे?
हम बनाए
बनाएंगे, रुक जाइए। सिर्फ उस पे नहीं बनेगा ना, सिर्फ उस पे बनने से होगा।
नहीं बाकी भी हमने
और अगर वो सब्सटेंशियल क्वेश्चन ऑफ लॉ आपके फेवर में डिसाइड होगा तो रिमांड के अलावा बस कोई ऑप्शन नहीं।
और ऐसे भी जब इन्होंने नहीं एग्जिबिट मार्क किया है और हमें मौका नहीं दिया तो इसमें प्रेजुडिस तो पॉसिबल है। और माय फ्रेंड
कब रख दे बताइए।
2 बार एडिशनल एविडेंस का पिटीशन रिजेक्ट हुआ, 2 बार फाइल किया गया था, एक 11 में एक 16, दोनों में अलग अलग, एक में जो लास्ट ऑर्डर से डिस्मिस था।
आज तो नहीं हो पाएगा ना, कब रख देंगे?
ठीक बता देंगे
नहीं दोनों एक ही साल का है, एक में फर्दर इन रिपोर्ट है, दूसरा वो जमींदारी
इससे नंबर 510 of 2016
दो
further
क्लियर है।
office is directed to place this case under appropriate heading on 11th November.
Here also this order was there, even then it has come to us.
गलती से आ गया है, लेकिन आपने आइए भी तो फाइल कर दिया ना।
हम तो हमने सही
तो justify हो गया।
अगर पर्सन के खिलाफ
There was a market serial number 13. I was expecting that it might be taken.
Serial number?
13. Just have to take. What I'm praying, because of paucity of time, it will not be able to be taken up today. I'm praying to an early date after vacations any date.
Early date आप choose कर लीजिए, आपको कौन सा?
It may be posted on 11th or posted on 11th.
11th हो?
Just after opening it.
ठीक है।
11th is.
11th is
Sorry. It will be 13th or 14th.
early date तो 6 तारीख होता है।
But हम हैं नहीं उस समय इसलिए हम नहीं बोल रहे हैं।
चल,
क्योंकि हम रहे हैं।
इनका जो डेट हो मन हो उसमें।
To bless.